2, 1.
Добрий день, шановні колеги.
Good morning, dear colleagues.
Розпочинаємо
Let's start our special joint meeting.
У засіданні беруть участь члени
In the meeting, we have members of the PCA present: Robert Heidenbroek-Heisen, chair of the PCA; Norman As, Mary K. Butler, remotely; John J. O'Sullivan, and Jessica Lott Thompson, also remote. Three, two, one.
Після технічної
After a technical break, let's continue our meeting. And I would like to inform that we have members of the HQCJ present: Михайло Богоніс, Віталій Гацелюк, will you come now, Ярослав Дух, Роман Кадисюк, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олексій Омелян, Роман Сабодаш, Руслан Сидорович, Сергій Чумак, and Галина Шевчук. I'm the presiding mayor, deputy chair of Oleg Kolюш. We also have secretary Natalia Vlasuka. We have quorum, and the special joint meeting of the HQCJ and PCI is announced open. I would like to inform that special joint meeting is broadcast live. I'm announcing the items included into the agenda. On compliance of candidates for positions of judges of the High Anti-Corruption Court with the criteria set out by Part 4 of Article 8 of the Law of Ukraine on the High Anti-Corruption Court. The list of candidates: first one, Ivasyn Oleksandr Romanovych, Romanenko Petro Valerійович, Bodnaruk Yuriy Volodymyrovich, and we also had in the list for today Kitov Alexander Vasilyevich, but in connection with the absence of the rapporteur, Pasechnik Andrei Volodymyrovich, I suggest to remove this item from the agenda. So, I suggest, do you have any other suggestions, colleagues, regarding the agenda? No? No other suggestions? Let's vote for the adoption of the agenda. Who is in favor? Please vote. Unanimously. So, okay, we've adopted the agenda, and I see no point to announce the rules. Please inform about the appearance of the candidates. For participation in the meeting, the invited candidates for positions of judges of the High Anti-Corruption Court have appeared. In particular, Ivasyn Oleksandr Romanovych, Romanenko Petro Valeriyevich, and Bodnaruk Yuriy Volodymyrovich. Please invite candidate for the position of the judge of the High Anti-Corruption Court, Ivasyn Oleksandr Romanovych.
Добрий день.
Good
Коли
morning.
будете я тут. Дивіться на
I'm
мене.
here. Look at me, please.
Коли будете надавати відповіді,
When you are giving answers, please do not forget to switch on your mic and speak closer to the mic so that we would hear you better. We are considering the issue of compliance of the candidate for the position of the judge of the High Anti-Corruption Court, Ivasyn Oleksandr Romanovych, with the criteria set out by Part 4 of Article 8 of the Law of Ukraine on the High Anti-Corruption Court. We have present members of the PCAE: Robert Heidenbroek-Heisen, chair of the PCAE; Norman As, Mary K. Butler, remotely; John J. O'Sullivan, and Jessica Lott Thompson, also remotely. We also have present members of the HQCJ: Михайло Богоніс, Віталій Гацелюк, Ярослав Дух, Роман Кадисюк. You will come now in a second. Олег Колюш, Ігор Кушнір will come soon as well. Руслан Мельник, Олексій Омелян, Руслан Сабодаш, Сергій Чумак, and Галина Шевчук. Do you understand the composition of the commission? I'm explaining your rights. You have the right to request recusal of members of the commission, to submit motions, and to provide explanations upon permission of the chair to express your positions, views, and objections, and to challenge the decision in instances set out by the law. I would like to emphasize that we are not considering any new materials submitted by the candidate if the candidate had a chance to provide such materials previously, but the candidate or other persons did not submit them to the PCIe or the HQCJ. If there are circumstances that simulation for input decision making upon initiative of at least 3 members of the PCIe or HQCJ and upon the motion of the candidate, there might be adopted the decision on acceptance of additional materials, provided that at least 3 members of the PCIe have voted in favor of such decision. Do you have any motions or recusal requests? No. Also, I would like to emphasize that participants of the Commission have to comply with the duties set out by the ROP of the Commission. Sabudash Roman Bogdanovich is the co-rapporteur regarding your candidacy. Please, over to you. Thank you. Good morning, Mr. Oleksandr. So, a brief report. With the decision of the HQCJ of Ukraine dated June 3rd of 2025, this competition was announced. By the established deadline, the Commission received an application from Ivasyn Oleksandr Romanovych on admission to the competition. With the decision of the HQCJ dated September 16 of 2025, he was admitted to the qualification evaluation and participation in the competition. Then he passed the qualification exam, and with the decision of the HQCJ dated February 4 of 2026, results of the first stage were approved. Pursuant to results of the qualification exam, the candidate received 295 points and was admitted to the second stage of the qualification evaluation, in particular the dossier examination and interview conduct. He is 42 years old. He is a citizen of Ukraine. In 2007, he graduated from private higher educational institution Kyiv International University. He obtained a complete legal education under legal sciences and he became a lawyer. In 2020, he graduated from Vinnytsia Trade and Economic Institute of Kyiv National Trade and Economic University and obtained higher education under philology, a specialty. In 2015, Ivasyn defended his dissertation under specialty administrative law and process, financial law, informational law, under the topic of judicial control in administrative judiciary proceedings, and obtained the academic degree of the candidate of sciences. In May of 2025, Ivasyn got the academic title of the Associate Professor of the Faculty of International Civil and Commercial Law of Kyiv National Trade and Economic University. Professional activity of the candidate. In 2008-2009, he was a lawyer in public union protection. In 2010 until 2011, for 3 months, he worked as a lawyer in LLC Organiczna Architektura. Then he held different positions in Kyiv National Trade and Economic University from 2011 to 2019, from a lawyer to associate professor. And starting from March of 2020 and until now, he has been the associate professor of the Faculty of International Private, Commercial and Civil Law in Kyiv National Trade and Economic University, which is also called the State Trade Economic University. And in 2020, the faculty has been renamed. He has total experience in the sphere of law is over 7 years, and he is fluent in the state language. His attorney's license was issued on November 26 of 2009, based on the decision of the Kyiv State Qualification and Disciplinary Commission of the Bar. In 2006, he was running as a candidate to Shevchenkivsk District Council in Kyiv, but he did not become the deputy. He took part in the competition in 2011-2012 for the position of judges. He took a part in the competition for the position of the judge of the High Anti-Corruption Court, and with the decision dated March 21st of 2019, he was recognized as terminating his participation in the competition because the candidate for the judicial office did not comply with the criteria set out by Article 8 of the Law of Ukraine on the High Anti-Corruption Court. He took part in the competition for the position of the judge of the Hague, announced in 2023, but he was recognized as terminating participation in the competition for the position of the judge of the Hague because of the failure to pass the practical assignment stage. He also took part in the selection for the position of the judge of the local court announced by the Commission in 2024. He was denied an admission to the competition because back there he submitted an expert from the information analytical system on criminal conviction as of February 25 of 2025, and he did not submit his autobiography. Right now, he's taking part in the competition for the position of the judge of the Court of Appeal, announced by the Commission on September 14th of 2023, and he continues taking part in it. For the decision of the Commission dated July 15 of 2025, he was admitted as getting 663.23 points, and he was recognized as confirming his capacity to administer justice in the General Court of Appeal. However, he did not become the winner of the competition to the Zhytomyr Court of Appeal because his score was lower than the score of the 10th candidate. So he did not get into the rating. That's it from me. Do you have anything to add to what I've just said? No, not significant, but I'm 41 years old. Yes, sorry. And 343.02. Quite significant comments. Thank you. Mr. Robert, over to you. Please.
Thank you, Mr. Chair. The rapporteur in your file is my dear colleague Norman Aas.
Good morning, Mr. Ivasyn. Yes, as Robert said, my name is Norman Aas. I'm a lawyer from Estonia, former prosecutor, and I'm your rapporteur. And thank you for participating this competition for our quite important job as a HAC judge. And also congratulations that you have reached this joint interview phase. We have already have had several written questions and answers rounds. Thank you all for your answers and documents provided so far. But as this is a public interview, and for the sake of the transparency and also for understanding the general public, I will cover some of them again. So, and please answer. If the answer is the same, you can use the same answer as you written down in your written answers. But I like to start to know better about your background as a lawyer. And so can you please briefly explain the legal positions what you have held within the Ukrainian legal system so far?
At first, I worked as a lawyer at an enterprises. Then, in 2009, I obtained the attorney's license. I engaged in attorney's activities. In 2011, I started working in Kyiv National Trade and Economics University at the position of the head of the legal department. Subsequently, in 2013, I started teaching at the faculty, and in parallel, I was holding the position of the head of the legal department. And I worked until September of 2021. I resigned from the position of the head of the legal department, so I stayed teaching only there. I switched to attorney's activities. Then, since 2009, I was engaged in parallel into attorney's activities. After the full-scale invasion, my main work was work as the attorney, and since January of 2024, I again have come back to the Kyiv National Trade and Economics University to the position of the associate position and part-time as the head of the legal department again.
Thank you. I'd like to ask some clarifying questions about your career as an attorney. Can you describe what categories of the cases you have worked as a lawyer, as an attorney? Civil cases, criminal cases, administrative cases?
Ну, якщо так, відсотково.
If we are talking about the percentages, then approximately 40% of cases were civil cases, about 30% of cases were criminal cases, and during different periods of time, more administrative cases, more commercial cases, but the lowest percentage was in administrative cases.
And can you recall, for example, over the past 5 years, how many criminal cases you have handled as attorney?
Якщо ми беремо
If we are talking about participation in court hearings, like in courts, then up to 10 cases. But if we are talking about participation in pre-trial investigation stages as a defender, in defense attorney or representative of a victim in pre-trial investigative bodies, then we would add about 5-6 cases to those 10 cases. Because with respect to some cases, I was providing consultations. Under some cases, I was involved into procedural actions as a representative, and these cases came to court or right now with the court.
And can you describe what kind of crimes they were or in the criminal proceeding, but you where you represented the clients? What type of crimes?
Ну, зараз я представляю клієнта у справі.
Now I'm representing a client in Holosiv District Court on abuse of power, giving a bribe, offering a bribe. So this is one case. Another case, Article 191, Part 5 on embezzlement, then falsification and bribe. So these are the criminal cases that also can be subjected to the anti-corruption court. Then I also had cases of fraud and light bodily harm.
I understood that you have handled also the corruption or corruption-related cases. So, what do you think? What is your most complex case so far? Of course, without disclosing any confidential information. So, but what do you consider the most complex case so far in your professional career?
Ну, мені, якщо ми говоримо про останні справи, то
So if we take the most recent cases, the most complex one was the one that I have in Holosiv District Court. It's still ongoing. The individual was arrested while taking a bribe, and I started representing her from the first day of their arrest. Why was it complex? Because during pre-trial, I realized that the crime was misqualified. And in that case, we couldn't be talking about a bribe in the classical form. We were talking about potential abuse of power. And throughout 3 months, I was persuading the prosecutor and investigator that if we were to select the circumstances or consider the circumstances that the prosecutor or investigator believe as proved ones, then we are dealing with a misqualification. As a result, the investigator changed the qualification of the actions, and now they are using the abuse of power qualification rather than the qualification as taking a bribe. Then there are also some violations on the part of the prosecutor's office when they send the indictment. And for more than 6 months, the case had been considered. Unfortunately, the first instance court did not support my position, but still, this case is still being heard, and this is the complexity of it. Then in 2011, there was another case that stood out to me because I provided services free of charge as a it was about hooliganism and inflicting bodily damage, and about 7 years of prison was meant as punishment. But I offer different position, and the number of years was reduced to just 1 year. And back then, that was a very emotionally charged case for me because I proved my position, I stood my ground, and I really was pleased with the fact that even though my work was free of charge, it brought some benefit, it made a difference, and the actions were qualified correctly, and the individual had the punishment that they deserved rather than something they did not.
One clarification. Have you represented the client so far before the High Anti-Corruption Court or no?
В судовому засіданні я клієнтів в антикорупційному суді не представляв. Я надавав
Not yet. I have provided consultations in civil cases about unjustified assets, and that's it. I haven't participated in court hearings in The Hague.
You mentioned that you have did quite several pro bono cases, but can you explain what kind of fee model do you use today? It's hourly fees in the cases, or what is your fee model as a private practitioner, as an attorney?
Я говорив про справу, коли мене призначали.
I mentioned that case, that pro bono case. That case was transferred to me by a self-governance attorney body. But from the very beginning, some cases I could do them pro bono, and the motives are different. I may appreciate that the individual doesn't have the appropriate budget, or might be interested in that particular case, or I would like to gain an experience in a case that is new to me. And especially after the full-scale invasion, I could do such cases pro bono, and I have got many requests, so I try to cater to their needs. And I have also been a lecturer, and I've got a couple of courses about corruption prevention. And after such lectures, the students turned to me asking for some consultations. And I also do that free of charge because this is a logical continuation of my lectures.
But when you offer your services not for free, but as an attorney, what kind of fee model you apply today? It's hourly fee, some exact amount hryvnias per hour, or what is your model charging your clients today?
Ну,
If this is not a pro bono case, but ordinary case.
якщо ми говоримо про
So if we take ordinary cases where I do charge my clients, we have two modalities here. I have two modalities here. First, procedural documents need to be prepared, and if we need to prepare a procedural document, there is a fixed price. And it can be done with me as an individual attorney or with an attorney association, because at different times of my career, I could be a part of an attorney association or practice on my own. So when we agree on the assignment, we can either have a fixed price for a service or an hourly rate. And then I either get an advance payment or step by step. So it depends on the situation. My client also can get compensation of their spendings as long as we have a contract, because without it, it could be impossible.
And the last questions about this topic. Can you have explained that maybe 10 years or beginning of your career you made different pro bono cases, but can you recall when you did the first case as attorney when you send out the invoices and charge the clients for your services?
Не призначав, бо я не почув.
When was the first case when you offer your services as ordinary attorney? You send out the invoices to the client and the client paid the invoices. When was the first case? Can you recall in your career?
Я почав
I started my entrepreneurship in 2004, even before I engaged in attorney's practice. So provided legal assistance, but at a different level. So my first case as an attorney was in 2009, and back then I mostly had legal entities as clients. We would conclude an agreement, or I would provide services to them on a monthly basis. And it was a well-spread practice, and I also sent them invoices on a monthly basis and got paid monthly. But I don't really remember which enterprise it was. It was a long time ago. DP Favorit Plus, LLC Sokil, and some other enterprises with whom I cooperated for a long time. So we would conclude an agreement, and they would use my bank details. They would sign a satisfaction note. I would send them invoices sometime, and other times I wouldn't. But the mechanism of payments was legal.
I understood that at the moment you are working also as a part-time associate professor at university. Can you explain, please, which subject do you teach in university? What kind of courses you're given to students?
Ну, я тоді з кінця почну. На сьогоднішній
So I'll
день я
start from the end. Today,
4
I
дисципліни, вибачте.
teach
Це
4
цивільний
courses:
процес, це господарський
civil
процес,
process, commercial process, practical, applied law, and short-term courses for government officials on declaration, submission of declarations, and prevention of corruption. Before, I also taught administrative law and process, ecological law, but it was early on in 2013, 2015. So since 2013, I have been teaching continuously, but I could have different workloads in different periods. And today I'm an associate professor, docent at a chair.
You said that you have been practicing law since 2009, and according to your bio, you have the founder of your own law firm, Case and Partners International, since 2015. Is that correct?
Так.
Yes.
According to the tax declarations, the first declared income from this your own law office was declared 2022. Wasn't there any income before that during the 7 years?
Давайте я проясню. Якщо ми
Let me explain. So if we're talking about income that I got personally from the law firm, then yes, since September 2021, I started getting income in the form of salary. The Attorney Association, the law firm, started functioning. So it was registered in 2015. Its activities started around 2015, 2016, and the income that they started getting, I submitted reports on that. Since September 2021, I have become the director of this firm, and I was the founder of it. And this firm started out having 2 attorneys. Then we could have 3 to 4 attorneys. Today we have 2 attorneys again. And based on our agreements with other attorneys, those cases that I could take from Attorney Association, from the firm, I actually spent the income on developing the law firm because we needed to invest in the website, in videos of different character, in ads. We needed to have our YouTube, to do content management on Facebook. Then our attorneys also received paid courses, and they needed to build their capacity annually. Then we also had an office until 2022. After 2022 in September, we refused the rent because we didn't have a big flow of clients. And when I became the director of the firm, I started getting a salary. Unfortunately, this law firm was not too profitable that we could, and we didn't really make much profit out of it.
understood I correctly that until 2022, you didn't have any income as a salary or as a dividends from this law firm?
До вересня 2021-го я не мав
Until September 2022, I didn't have income personally myself. I didn't have income from this law firm. I would use the costs to pay for other attorneys' courses. The law firm paid my membership fees to attorney self-governance bodies. We would also buy material and equipment for the law firm, computers, paper. But I individually did not benefited from the income from in that law firm.
Did you also, as an attorney, serve the clients through this law firm in those years, or when you started serving the clients through this law firm? And
Yes, I did.
You started with that 2015 already or later?
Ну, в 15-му я не впевнений, але не виключаю.
I'm not sure about 2015, but it might be 2016. This is the exact number that I can date.
How many cases you have had during the years in this law firm?
Ну, якщо рахувати десь до 2021 року.
Until 2021, I may have had 30 cases throughout all my activities there. I may be not able to give you the exact number, but about 30 cases.
But it means that you basically worked for free in this law firm. You had your cases, well, quite a many during the years, but you didn't have any income for that cases as well. This was just a hobby.
Адвокатське об'єднання, дивіться, була категорія справ абсолютно безкоштовна, де ні адвокатське об'єднання, ні я не отримували кошти.
Look, there was absolutely free for pro bono category of cases where neither me nor law firm received any money. There were a category of cases where the law firm concluded agreements and received money. Me personally, I have not received funds from this law firm because I had main place of employment. At 2015, I defended my academic work, and there were activities more related to academic area. And so the idea back in 2015 was the following: to build my name, to build, so to say, some kind of raising awareness, information about me. And so all these funds were mainly aimed at these areas and these dimensions. So with this purpose, in August 2021, I quitted the job of the head of the legal department because at that moment I had already understanding that I have some clients, I have certain more or less stable income in that law association, and at that moment I wanted fully to move to attorney's activities. But unfortunately, the full-scale invasion changed so many plans.
Thank you. Yes. According to the material from 2011 to 2021, 10 years you served as a head of the university's legal department. September 2021, you resigned. And the question is that in the same year, between September and December 2021, your law firm concluded 4 contracts with the same university. And 2022 and 2023, your law firm concluded 5 more contracts with the university. On those initiatives were the first contract between the university and your law firm concluded in September 2021, short after your resignation as the head of legal department of the university.
So after quitting my job, I communicated with the leadership of the university. I motivated my wish to quit my job because I want to be more engaged into the attorney activities, and rather than some routine issues related to the university. But at the same time, I wanted still to be a lecturer. So upon the mutual agreement, I quitted my job of the head of the department, but I kept working for part employment, half of the full day as a lecturer at that university. But starting September, maybe a little bit earlier, the talks were going on about potential reorganization at the university structure in order to implement provisions of the law of Ukraine higher educational facilities. And there were certain things which were not usual. There were so many different legal activities which were related to the division of the university into 2 different educational facilities. And it means that there was a need to engage a specialist who will handle such issues, which had never been done before by anyone. So this proposal was expressed. I accepted this proposal, and there were certain legal activities related specifically to this organization in terms of property, immovable property, issues related to transfer of employees, because there was a need to handle comprehensive tasks in terms of organizational activities regarding transfer of employees, because the task was to preserve the employees and to avoid a situation of potential negative consequences for employees because of this reorganization. And that's why there was a proposal expressed to conclude such contracts. And my law association, so at that moment, almost 90% of tasks were done by me. My colleague, who was also in this law association, and it means that relevant measures were taken. So depending on the tasks received, they were performed. The reorganization process ended on 31st of January. Registration of 2 legal entities was done. All employees kept their working positions with the same working conditions. And it means there was also a need for communication with the Ministry of Education regarding everything related to the state property in terms of the distributed... Sorry for a long speech, but there was a proposal suggested to me. I accepted it and provided relevant services as an attorney.
In your law firm, was you main responsible attorney to serve the university, or were also other attorneys involved, or was it just you?
I carried out major part of the work. Also, my colleague, she's also in this law firm. She also performed some tasks, but the number of those tasks was less than the one I did.
Can you remember, did the contracts with the university constitute a significant portion of the law firm's income in 2021 to 2023? What was the portion of the overall revenue from those contracts with university? More than half, 90%.
Якщо ми говоримо про
Speaking about
2021
2021, it was approximately,
мені здається,
I think that
20%.
20%.
Якщо ми говоримо про 22-й,
2022 and 23 wise,
близько
it was approximately 40-50%.
But from your own everyday activity, did you have also other cases, or your main client was the university in those years?
Якщо ми говоримо про 21,
So,
22,
regarding 21, 22, 23 years, of course, I had also other clients
які мали контракти
who
з адвокатським об'єднанням,
had their contracts signed with this law firm, and I was engaged to carry out certain services and tasks.
Let's go to another topic. We know that you also run to these hub job positions during last competition 2018, and that time you haven't passed the competition, and the PCIA and HQCJ found that you are not meeting to the criteria of integrity for various reasons. How do you assess these conclusions set out in that decisions today, 5 years later already? No, it's 8 years later.
Я проаналізував
I analyzed
відповідне рішення
this decision
і прийшов до висновку,
and
що
made conclusion
на той момент
that at that moment I didn't take all measures in order to fulfill all requirements that I had as a candidate according to provisions of the law. Regarding my failure to declare the vehicle, in further declarations I declared it with my understanding that at that moment I made a mistake. That mistake I corrected. Regarding other aspects, I think that as of now, I'm fully compliant with the requirements under the law. From my side, I take all measures in order to fulfill requirements regarding candidates, and to my personal opinion, I have my lessons learned, and correspondingly, as of now, those situations that were present at that moment during that competition, I can say it's that, yeah, I corrected them. I don't know what to add more.
Thank you. We know that this negative decisions was taken January 2019, and you have said today that you have you learned lessons. But on 1st of April 2020, we know that you published a Facebook post on how to declare gas that you have always had but have not previously declared, and you recommended in that post that the most suitable way is to declare those unknown income gifts from your relatives. How do you explain publishing such a recommendation only a year after the negative decisions of the competitions?
Regarding the situation and publication of this post, I was thinking a lot regarding this matter. I provided my explanations both upon request of the PCIe and also during the interview to the Zhytomyr Court of Appeal. This issue was also raised there. And unfortunately, my wish to be useful to my audience who listens what I say, who reads what I write. So it played a bad joke. Why is it so? Regarding the issues of corruption prevention, I have been providing lectures to civil servants since 2016. The university wins different competitions within my short-term program. So specifically for the aim of provision of my course, and I provide those lectures. So it means that those lectures in 2016, 18, 17, my lectures were focused on declaring process. And unfortunately, because of a lack of understanding of legislation, many of participants of my lectures asked how to declare cash money. Many of them were afraid that if they declare those cash funds, people just, some offenders will come to their home, will steal those money, will rob them, and so on. So maybe because of lack of understanding of legislation, they thought that it's better not to declare at all. So first of all, I tried to explain to them that this declaration process is aimed at protection of civil servants. My post in social media was more of a generalized conclusion. But those people who read my post, including the PCIe, including the public in general, they had a chance to evaluate this post from different perspectives. Because one of the situations that they asked me about, I mean my audience, that's aunt gifted some money to a civil servant, and she didn't declare it, she failed to declare it. What shall she do? So my publication, my post so it appeared that my post could be perceived in a different manner. As of now, I deleted this post, even though only 6 persons read this post and gave me some kind of, a response. But I'm aware that, yes, I allowed wording which should not have been used. At the goal, the intentions that I had and the result that I received appeared to be contradictory. As of now, the public and Public Council of International Experts, based on our exchange of communication with you, so tells me that this publication, this post, was perceived in absolutely different manner rather than I planned from the very beginning. The only thing that I can say that indeed I published it, but I realize that the wording, which was not very well chosen, or the conclusions made based upon it, led to such misunderstanding, and we waste time of the Commission to discuss it. Sorry, please be more concise. The question was not very difficult.
About this issue, questions more. Have you ever acted on this recommendation yourself?
No, I didn't act like this.
Okay, of course. And what is our concerns? Almost every second candidate, also in these competitions, have declared gifts from their relatives, and of course your post raises some doubts for everybody now that that's a problem for us. But okay, the last questions from my side is we know that in 2021 you published a scientific article entitled "The Application of Statutes of Limitation for Persons Included in the Register of Corrupt Officials." And you concluded in this article that current law should provide for the possibility of rehabilitations for those convicted corrupt people whose sentence is already served. Can you explain what is the problem for you in present legislations in Ukraine and why it should change in this regard, that some sort of rehabilitation possibility should be placed for the convicted corrupt people?
Можливо, є якийсь момент з перекладом.
There is some point with translation because my idea was the following. Persons who are convicted or who have been brought to administrative or disciplinary liability are included in the respective register of persons who have committed a corruption offense. And the idea of my publication was that I believe that after some specific period of time, the person should have the right to be excluded from this register. And I would like to draw your attention that on July 17 of 2025, the Parliament of Ukraine adopted a law on respective amendments to the legislation, including, among other things, with respect to the possibility of removal of a person from the respective register in case of some specific circumstances, which I believe. I do not think that my publication was read by members of the parliament, but I understand that my thoughts got reflected, among other things, in the form of respective amendments to the legislation. And right now, the NACP has started removing persons from the register of persons who have committed corruption offenses or have been brought to their liability in some other way. So I believe that my considerations, my thoughts have also been supported through this law, even though 4 years later after my publication.
Thank you, Mr. Ivasyn. My more than 40 minutes has passed very quickly, but thank you, and give the floor over Chairman.
Thank you, Norman, for all your questions, and thank you for all your answers. My dear colleague John has a question.
Yes, I'd like to talk to you a little bit about your Facebook post that you say was misinterpreted. I don't see how this was misinterpreted by other people. The topic of the post was how to declare cash funds that you have always had but did not previously disclose. And your advice was that an aunt, uncle, or other close person give these funds to the declarant under a gift agreement, and the person then purchase real estate with these funds. That seems pretty clear to me to advise people to evade their legal obligations. Why do you think that reading that someone misinterpreted it? It seemed to me that they interpreted it exactly as it's stated. Could you please explain that to us?
In my publication, I had not only this suggestion, I had two other suggestions. The first one was to correct the mistake if there is a technical possibility to do that, that is to submit the corrected declaration. Back then, the law did not provide an opportunity to address the NACP. Later on, I think in 2023, this opportunity was granted to people. And my second suggestion was to submit through the account of declarations and notification on the mistake. And the third suggestion was if that you had a gift from close persons, but if close persons gifted it, but there is no income, then of course it additionally points out the illegality of this transaction. That's why I did not have any intention to do that. Of course, I understand that nowadays, without the context that I've just described, and without the full text of the publication, of course, this conclusion looks like an advice for action.
Thank you. No further questions for me.
Back to you, Mr. Chair. Дякую. Я в свою чергу
Thank
передаю
you.
слово
And
Роману.
I am passing the floor to Roman Sabudash, please. Thank you, Mr. Oleg. We have some questions left. Let's try to generalize some of them because you've already discussed them at the panel's meeting. I'm talking about your savings in 2015, the land plot of 2017, the cost of land plots, and Hyundai gets a mistake in the declaration. I have on the question, do you agree with respective conclusions that the Commission has already reached in this regard, or would you like to provide some additional explanations regarding that? And we can go step by step if you want. With respect to the vehicle, I can say that the decision of the HQCJ or the joint decision of 2019 were not challenged me. So you agree? Yes. Accordingly, I agree with conclusions. Okay, but there are some circumstances that we have to clarify. They have been concerns from CSOs voiced regarding them. Mostly you've already answered about that, but still, let's follow up on some aspects. With respect to the circumstances under which you acquired real estate object in 2015, that was the land plot and other real estate objects. Can you briefly, please, describe the situation under which you obtained that and grounds? That was not the subject matter of the discussion. That's why I'm asking that separately. In January of, in March, sorry, of 2020, no, or in January, I might be mistaken. I sold my apartment in the city of Kyiv with the area of 24.7 square meters. I got income from that. Then in March, I sold my vehicle Honda Accord. And in May, I bought one half of the garden house, which was previously owned by my family as well. And I bought half of the land plot. Maybe I'm a bit confusing in my explanations, but in 2018, my family, including me and my wife, together with our joint friends, bought a garden house and land plot in half. So one half was bought by my family and the other was by our friend. And the same was about the land plot. In May of 2025, upon arrangement, we bought this half, this other half of the cottage house and land plot. So this way you became the owners of 100%. So that's okay. I have a question that was asked to you by the CSOs as well. You provided the explanation. That's about the sources of origin of funds for that purchase. We can approximately calculate that again from memory. Unfortunately, I do not have this document with me. But look, I will help you. From your explanations, you said your income in 2016 were 217,000. In 2017, it was 258,000. Then 235. Next year, I'm approximately rounding up for the understanding, and etc. 300,000 in 2020, and in 901,000 in 2024. Then you are making a statement that you had cash savings in the amount of $22,000 and 6,000 euros plus 250,000 hryvnias. These were your savings, plus you are adding income of your wife. In connection with this, I have a question. On average, how much do you spend per year? Here, everything depends on the period. This year, for example, now I live on my own. My wife and child are in Germany, and I'm spending maybe, if we do not take into account the credit that I'm repaying, okay, if we take that into account, then about 18,000 hryvnias per month, that's my credit payments, and I'm spending approximately 15 up to 20,000 hryvnias per month. Yes, 15, 20,000 hryvnias per month. So that's approximately 200,000, 250,000 per year. Yes, yes. How did you manage to make savings then? Okay, then let's start. Are we talking now about the purchase in 2025? Yes, in 2025. Please don't forget that I sold an apartment that cost, if I'm not mistaken, about 1.2 million hryvnias. I sold a car for 200,000 hryvnias, and I had previous savings. I paid for my the other share in the house and land plot. I think it was 1.6 million, but that's from memory. I might be mistaken. Okay, I'm more interested about your savings. I understand. And basically, math is fine if we take into account your explanations and savings. My only question is how you managed to accumulate savings. Because income in the amount of 250,000 hryvnias is not the income that would allow to make active savings. First of all, I started accumulating savings since the start of my professional career, being an individual entrepreneur. And as of 2011, I provided reports as an individual entrepreneur. And as of 2015, this first declaration that I showed, I had approximately $20,000. The currency exchange rate was 8 hryvnias per $1. In 2011, I clearly remember that I had income from entrepreneurial activities in the amount of 146,000 per month. That was collection of indebtedness. And that was back then, only that amount was $18,000. Okay, and so accordingly, these funds were kept by me in dollars. You were acquiring assets back then, so that's why when we were analyzing that in the decision of the Commission dated 2025, this issue was not raised because your income and expenses were more or less correspondent. I had only a question about 2025, where you had those savings as of 2025. If we analyze my declarations, I printed them out somewhere. In terms of declarations, figures, everything is fine. My question is only about the sources of your savings. In 2022, for example, as of 2022, I had 250,000 hryvnias, $22,000, and 6,000 euros. So if we calculate those savings, but again, my last declaration was filed in 2018. In 2015, I had this amount of 650,000 hryvnias. Then I partially exchanged it into dollars. And per month, annually, I was setting aside a specific amount of funds. You're asking about my current expenses. Back then, my expenses were a bit lower. And we had a chance to live for a lower amount. So accordingly, every year I was setting aside some money as savings. If we're looking at my income in 2021, 2020, I was setting aside a savings more than a half. So accordingly, I managed to accumulate these assets. And in 2025, basically the sold apartment and sold car and just like 300,000 hryvnias on top. And that's how I managed to pay for a half of the house and land plot. So even without savings, everything was covered by obtained income from the sale of real estate objects. Okay, understood. After the end of the interview, please find in the network statistical data regarding average expenses of the population in Kyiv, and that's why you will understand why I ask these questions. But I would like to remind you that that is prepared based on average incomes. Okay. They're a bit higher than what you named. But if you manage to do that, then I can only support your position. I have another question that was asked by the civil society. Can you explain the exchange done by your brother? Yes. In 2019, he concluded an agreement for participation in the cooperative. Back then, the construction, if I'm not mistaken, it started in 2016, then it was suspended. It was quite problematic. And he concluded an agreement, and he was gradually repaying this installment. Then, when the building was commissioned, and accordingly the cooperative registered the right of ownership for it, he exchanged that shareholder payment for that apartment. So that's how the transaction was done. Because as far as I understand, the legislation does not allow the cooperative to sell. They can only get money from these contributions, and that's why they chose this manner of the legal transaction. With respect to his income, I provided data. Yes. So, until 2013, he lived in Dnipropetrovsk region. Accordingly, he got some income. He was setting money aside. Besides, they had a garden, and he managed to accumulate some savings. And then, gradually, until the moment of the conclusion of that agreement, he was managing to pay out that amount. So, accordingly, since the agreement was concluded, but the building was not commissioned for a long time, and that's why the developer allowed him to pay that in installments. And accordingly, I provided explanations and how he managed to get this property. Okay. Thank you, colleagues. I have no more questions. In the decision of the Commission, there was a matter about the decision of the Supreme Court, but the question was asked, and as far as I understand, you also agree with that decision, and that you do not have any concerns regarding that. That's it from my side then. Okay, thank you, Mr. Roman. Then I will ask a question. Now me, and then please. Please tell me. In the field of the application where where there are references, you do not mention anyone. Based on interviews that I watched previously, I would like to say how I thought about that. Since the competition to the Court of Appeal was announced previously, so the references were received from 3 persons whom I mentioned in that application, and accordingly I thought that since the dossier is the same, so those references are already in the system, and that's why I did not mention them again during this competition. Now I understand that I had to mention them here. Okay. And now about skills for working the anti-corruption court. If you are appointed, you will have to deal with lots of procedural aspects. One of them are materials attached by the claimant evidence in the criminal proceeding in the understanding of the CPC. I believe that yes, based on those facts, that materials received are a ground for entering this information into the register. But the evidence should be received following the procedures stipulated by the law after entering data into the register. Of course, I understand, but they would not have been entered. Is there any ground for entering this data into... Okay, I will rephrase my question. In what instances these materials can be recognized as the evidence? If that is information that is provided by the same whistleblower. Okay, understood. Colleagues, do you have any other questions? Ruslan, then Sergey, and then Ruslan Ivanovich. I have a very brief question. In your application data, we see that you are a member of CSO rights advocacy group, Know Your Right. That is accurate. Yes. Tell me, please. It's not non-profit organization. Yes. But still, that's a legal entity. It should function somehow. Can you inform us how do you cover expenses regarding activities of this CSO? The CSO was established in order to carry out information awareness campaigns and to take part potentially in grant activities, maybe to obtain some financing. But nowadays, all the expenses are actually borne by me because
тої активної діяльності, яка планувалася, вона
the active activity that was planned, it was initiated, but with the start of the full-scale invasion, unfortunately, it's not implemented to the full extent. Why am I asking that? Because I looked at the data, official, open, publicly available data. I do not see any financial revenues. This organization does not have any revenues. Yes. Zero reports. Tell me, please, the video channel, Know Your Rights. So that, yes, I'm managing it. I managed it before the start of the full-scale invasion, because after the start of the full-scale invasion, unfortunately, activity has been suspended. The last video was uploaded a year ago to the channel. No, maybe that's not my channel then. Maybe No, that's just the first channel. No, I mentioned my channels in the application, so maybe not mine if the video was uploaded a year ago. Okay, I'm just drawing your attention. Maybe someone used your the name of your CSO and under your brand is publishing videos, because those are legal videos. So please pay attention to that in order to avoid confusion with the persons who have no relation to you. Thank you. Please, Sergey.
Please. Thank you. Alexander, to continue the topic of your Facebook post, and in the 6th appellate court, they raised the same issue. But actually those issues, what was earlier, the lecture in the 6th appellate court or the Facebook post? I think I first gave lecture to the 6th appellate court, and I also give such lectures in other courts like commercial court. That happened in 2020, correct? So I would like to understand your position from the point of view well, I'm not talking about self-preservation instinct. We have the decision as of 2019 at the Hague competition about your non-compliance, and you answered to Norman saying that your lessons are learned on your part. Then in August 2019, the Hague Commission announces the competition to the Court of Appeals, and you applied to this competition. Among the candidates, you stated Kyiv. I'm talking about Kyiv appellate court. So we've got the decision of 2019 of non-compliance. Then you say that you learned the lesson, and then you apply to the competition to be a judge of an appellate court. And while being a candidate in that competition, you allow yourself to make such posts, as if you are just an attorney providing consultations. But at the same time, you were a candidate in a competition for the judge's position in an appellate court. Could you comment on that? How is that possible? How does that go hand in hand?
Я, звичайно, розумію, що той намір, який я мав, і той
I
результат, який ми на
appreciate
сьогоднішній день
that
отримали,
the intent that I had and the result, the outcome that we have now
з цього приводу я сказав, я вже пояснив,
are not
можу тільки
proportionate.
сказати те, що
And the only thing that I can offer,
мені нема що сказати.
well, I actually have nothing to add.
Я розумію, об'єктивно, да, що це була помилка.
Was it a mistake? Yes, it was a mistake in the wording. I'm just concerned that because you were a candidate to the judge position in appellate court,
Я завжди керувався ідеєю,
you
тому що
did that anyhow.
коли до
I
мене
was
звертаються,
also
як мої слухачі,
informed
клієнти,
by
то
the
намагався
idea.
допомогти
My
і
work
підказати
has
в
always
аспекті
been informed
ситуації, яка в нас склалася.
by the
Фактично,
idea that
якраз і
I
стосувалася
want to be
економіки
useful. I want to
людських
serve
ресурсів. Звичайно, що
those
ті
who turn
висновки,
to me
які,
for
на жаль, можна
advice.
зробити,
And
то
the conclusions that someone
моєю ціллю
may
не було
draw
нічого. Я
out of
ніколи
that
ні з
post
клієнтами,
can be
ні в
different.
своєму житті
And
отим
in
висновком,
my personal
про який
life and in
говоримо,
my
що можна
professional
краще
life,
інтерпретувати інформацію, ніколи не користувався, ніколи
I
нікому
have
не
never
рекомендував, саме в
took
розумінні
advantage of
як
that
механізм
piece of advice that I
приховування
allegedly
таких
gave
коштів.
in that Facebook post in order to hide income. Thank you for your answer, Ruslan. Thank you. So, my question that I wanted to make has been already discussed, the question around the Facebook post. But let us approach this from a different side. Imagine being a hack judge. The competition played out in your favor. You are being appointed, and you have been appointed, and you have a case where a suspect has charges, has corruption charges, and he committed some violations. The declaration, following your advice, the way he says it, would it be a reason for you to doubt your actions? So the suspect would say that he had thought that he had acted appropriately because he followed your piece of advice. Well, the suspect, that is, an individual can self-recuse, but there would be no circumstances for me to recuse myself. If we make self-recusals on any grounds, who would consider the case? I'm sorry, I'm not done yet. So it happens for the first time to me. And just to continue with my next question, in order to understand whether you are knowledgeable in procedural issues, a notion of whistleblower is stated in the anti-corruption law and also in the criminal procedural code. Is there a difference between whistleblower according to the anti-corruption law and in the criminal procedural code? And if yes, then what are the differences? The CPC defines the whistleblower from the point of view of a criminal offense. And in anti-corruption law, we define a whistleblower in different cases: administrative cases, civil cases, criminal cases. So the notion of a whistleblower in anti-corruption law is broader and also enables the whistleblower to report about the circumstances related to other individuals and other circumstances beyond criminal ones. So, If it's about criminal liability, individual reports about corruption or corruption-related cases, they can be defined as a whistleblower within criminal procedural code. And there are no other definitions of whistleblower according to the CPC. They just report about the circumstances. Well, if we talk about the characteristics, the whistleblower needs to have a reliable information about the circumstances and inform about real events, not just their assumptions. Of course, there are certain obligations that the whistleblower has to assume, and the main one being the veracity of the events they report. How can they get the information about those events? Because of their field of activity, as they are performing their professional duty, they learned about certain circumstances, or the whistleblower got different offers or proposals, and it was clear that the other party meant to commit a criminal offense. What are the rights of the whistleblower according to CPC? The whistleblower is entitled to get information about the process of the investigation. So the status, the whistleblower, what is his status? His status equals to the claimant, and he's entitled to a reward. Thank you. Any other questions? If there are none, then Oleksandr, you've got 1 minute to inform the Commission of something that you haven't yet informed them of. We have talked about all the circumstances and I provided explanations. Thank you. Thank you for your participation in the interview. And the interview is over.